90 days.
Yeah. Can you hear me, Judge?
Yes.
It was before this, before the, I want to say March 15th. Oh, are we live?
The mic is on, Linda.
Remain seated, come
morning,
on,
Your Honor.
reporters now in session.
Good morning to everyone. Calling the master calendar, calling our People versus Jesus Ramos.
Jason Westerfeld, Public Defender's Office, on behalf of Mr. Ramos. Mr. Ramos is present in custody on his way over to council table, and he is being assisted by a Spanish language interpreter.
Sandra Garcia for the People.
Now, my recollection is that this was a case that we had discussed, council and I, last time it was on calendar, and the public defender, Mr. Westerfield, you were going to provide some research.
Yes, Your Honor. I sent an email to the people and the court with the what I believe to be the appropriate research. Did the court receive that email?
I did. And this matters.
I'm sorry, Judge, I'm sorry, but that last part was muffled for him. I sent an email to the people in the court and then it was muffled on my end.
I believe that email had the appropriate research.
And the record should reflect that Mr. Ramos is being assisted by an interpreter in the Spanish language. Madam Interpreter, would you please state your name and credentials for the record?
Yes, sir. The interpreter's name is Ana Garza Gonzalez. She is certified for Spanish by the state of California, 301629. Her badge and oath are on file.
Thank you, Madam Interpreter. Counsel, again, it's my recollection that there were discussions off the record between the court and counsel, and the resolution of this case was dependent upon the court's reviewing that information provided by the defense attorney. I've had the opportunity to do that. I'm going to pass this matter until the end of the calendar so we can address other matters. It's my understanding that this case would not be going forward to trial today. Is that accurate?
I think that's accurate.
That's accurate, Your Honor.
All right, we'll pass Mr. Ramos's case for a moment. Calling the matter of People versus Travis Nolan.
Here for the people.
Is Mr. Nolan present?
Here.
Good morning, Mr. Nolan. And what is the status of this matter?
I'd like to start with the motion and limiting in conjunction with.
Mr. Nolan?
I'm the what's motion?
Mr. Nolan, the question is basically where this matter is ready to proceed to trial.
Yes. And actually, I need to process forms that my previous lawyers did not file that they were supposed
Judge,
to.
I'm having a hard time understanding for some reason.
Okay.
Maybe you can sit at the microphone or something.
Deputy Garcia, can Mr. Nolan step forward at council table?
Yes.
So he's closer to the microphone?
Have a seat right now. Speak up and speak into the microphone.
Now, Mr. Nolan, in master calendar, the concern is whether the parties are ready to proceed. So I asked the question a moment ago and you said that you were ready to proceed to trial. Is that accurate, sir?
Yes.
And appearing for the people?
He came for the people, Your Honor.
And Mr. Kim, are the people ready to proceed?
Your Honor, I did give Mr. Nolan additional discovery this morning, specifically a CD containing 911 dispatch and Axon videotapes. I did receive information from Mr. Nolan that he did not have that previously. So that was given to Mr. Nolan today.
Mr. Kim, does that mean then that the people are not ready to proceed this morning? Mr. Kim?
We will be asking for a brief continuance, Your Honor, just to have Mr. Nolan review of the discovery. But but if it's Mr. Nolan's wish to go forward today with the trial, I would ask for a trial date today, and we'll be ready at the next court hearing.
Mr. Kim, Mr. Nolan, we're going to pass this matter so that you two can discuss the date which you will both be ready to proceed.
Your Honor, I'm currently ready. He said that he's not ready because I need to review information. I've reviewed the information previously, and there's only a slight bit of the information I wasn't privy to. So it's not something that's necessary for me to proceed.
Okay.
Your Honor, then we'll proceed. We'll be ready, whatever date.
Mr. Kim, today is the date set for trial.
Your Honor,
It's not a question of whatever date, unless you two are considering a different date.
Your Honor, the procedure, what happened is last Monday, we were set for trial. Mr. Nolan was not in court last Monday.
That is a lie, Your Honor. I was here and they would not admit me into the building.
The court,
Excuse me, gentlemen, excuse me. I have other cases that must be heard this morning. We will pass this matter until I can give it the attention that it deserves. Please be seated. We'll come back to your matter in a moment.
thank you, Your Honor.
Thank you, sir.
Calling matter People versus Jack Henderson.
Morning, Your Honor.
Good morning, Mr. Snell.
I'm wondering if the co-defendant is on calendar today as well, Jaquisha? It's on
Good morning. Good morning, Your Honor. Irene Luna with ADO. I have Jaquisha Henderson. She's the co-defendant in this case. I did email your clerk on Friday. Ms. Henderson has been ordered to keep the same dates as the co-defendant, but Odyssey reflected that this date was vacated for her despite that order and set out to July for settlement conference. And I believe that's because she was released from custody. I have asked her to be present this morning in my office. She did call at 8 a.m. this morning to let me know she's running late, but that she did intend to be here.
Right. And the co-defendant's case, Ms. Luna, was set for what date in July?
I'm sorry, Your Honor, I didn't write it down, but I'll look it up right now.
Thank you. And for the people?
Justine Keel.
Thank you.
And Your Honor, I'll beg my appearance. Jeremy Snell with FAC on behalf of Mr. Henderson is at counsel's table.
Thank you.
And Your Honor, today as to Jack Henderson, people are requesting to trail to Thursday. The victim has not yet been served. My office did have some contact with him over the phone this morning. He, it appears, received the subpoena in the mail, or excuse me, that was left on his door, but is not willing to come in on that. So I need some more time to have my investigator personally serve him. And then I think as to Ms. Henderson, there will be a plea. I just submitted a first amended information. It'll be a plea to count 2, and we can take that up whenever she's here in this department, or if the court prefers, we could send it to 34, which is the home court.
And the plea is not a package deal?
It's not.
And concerning Mr. Henderson, Ms. Keel, what date are you requesting?
I'm requesting Thursday, the 18th.
And Mr. Snell, on behalf of Mr. Henderson?
We're ready. We object to any continuance. The DA had several months to get that subpoena, him personally subpoenaed, and to try to get him here today. So I don't think even a few more days is going to matter. So we're ready to go today.
And what is Mr. Henderson's timeout date prior to any emergency orders issued by the Chief Justice?
Well, Your Honor, under my understanding, I would be saying it's today. I'm not sure that's going to be my position. My client wants to go today.
Mr. Snell, I'm not asking you what your client wants to do. I'm asking you, what is the timeout under 1382 prior to the Chief Justice's emergency statewide order extending all trials out 90 days from their timeout date under Penal Code Section 1382?
But Judge, you're going to have to make that call.
It was April 20th, Your Honor. And so I believe it's now July 20th with those orders.
Anything further concerning Mr. Henderson?
Your Honor.
Ms. Keel, anything else?
I just want to clarify as to the amount of time that's passed. My office was not personally serving subpoenas for at least a bulk of that time due to the COVID pandemic. I believe in the last couple of weeks they've begun to do so again, but I have nothing else to add.
All right, concerning the defendant, Jack Henderson, this matter will be trailed till June 18th, well within the timeout period as established by the Chief Justice under the emergency orders given the pandemic. The court does not see any prejudice to Mr. Henderson if this matter is set over an additional 3 days from the current date set for trial. Anything further?
No, Your Honor.
No, thank you.
Thank you, Mr. Henderson. You'll be back in court on Thursday.
And Your Honor, as to Ms. Henderson, the Odyssey reflected a date of July 17th for a settlement conference only in Department 34.
And Ms. Luna, you're anticipating Ms. Henderson to appear sometime this morning?
Yes.
My suggestion then, counsel, concerning Ms. Henderson is that Ms. Luna, if she does in fact appear, you go over a change of plea form with her, and the matter is currently set for July 17. That date it can go forward for the change of plea in Department 34. If counsel wish to have it expedited, then you can contact this department to place it back on calendar for the change of plea.
I'm going to defer to the people. I know it was both of our intentions to have it done today. Ms. Henderson is due, she's pregnant and due in about July. So I was hoping to resolve it and avoid any further continuances down the road if she went into labor.
If that's the understanding, then we can trail it to the end of the calendar this morning.
Thank you. And I'm going to call her and get her time estimate.
Great. Thank you both. Calling the matter People versus John Michael Danny.
Lena Farnese for the People.
Good morning.
Good morning, Your Honor. Mark McIntyre.
Good morning.
Mr. Denny, he's present in court in custody.
Good morning. And the status?
Defense is ready, Your Honor.
Ms. Farnese?
In this case, there is a co-defendant who is set for a settlement conference in Department 31 tomorrow. I'm asking that this case be set over for a date, well, for tomorrow in Department 31 to match it up with the co-defendant. And I am hopeful that we can select a trial date where both defendants go to trial at the same time tomorrow.
Mr. McIntyre?
Your Honor, we would object to any continuances. My client has been given, has declared a stat set on all previous dates. The timeout was originally May 18th.
I'm sorry, I didn't understand, Mr. McIntyre. My client has declared and I didn't get.
Okay. We object to any continuances. As far as Mr. Danny, we've stat set and have not given any time waiver. The last timeout was May 18th. The co-defendant is out of custody and previously was represented by Annette Smurr. My understanding is that she is substituted out. So we feel it's unjust for my client to sit in custody with the co-defendant out of custody and given general time waivers. So we would object, but we would give a general time waiver if the court be inclined to release him.
And you did state that the timeout date, according to the statutory setting, was May 18th, 2020?
Yes.
The original, oh, I'm sorry, go ahead.
The original timeout date was May 18th before all the emergency orders and what have you.
And you are aware of the Chief Justice's emergency order, which sets out the timeout dates 90 days beyond their normal timeout date under 1382.
I understand, Your Honor. Yes.
Okay. Anything further, Ms. Farnese?
No.
Is the matter submitted to the court's discretion?
Yes.
It is, Your Honor. I would add that this is My client's 24 years old, no prior criminal history. This was $200 at Home Depot. So we'd ask for an OR release, Your Honor.
I'm going to assume that that has previously been addressed concerning his custody status, because I know that many of the individuals who were previously in custody have been released based upon a number of factors, but primarily based upon the pandemic. At this point, I'm denying that request. This matter will be set over for a settlement conference. That'll be tomorrow in Department 31. Mr. Danny, you are to be present that date and time. Ms. Furnesi, what date do you intend to request for the trial of this co-defendant case?
Well, I was hoping to speak with the attorney on the other defendant and then decide, but I think like 2 weeks out would probably be fine.
Well, my suggestion would be that when you make the appearance in Department 31, you would have had the contact with the defendant's co-defendant's attorney, and that you have a date in mind so this matter for the co-defendants may proceed together. Anything further?
No, Your Honor.
All right, thank you. Calling matter People versus Nicholas Lusk.
Yeah.
Please state your appearances.
Hi. Good morning, Your Honor. John Ringy on behalf of Mr. Lusk, who's present in court out of custody.
Good morning, Your Honor.
Oh,
Deborah
I'm sorry,
Miller.
in custody.
Deborah Miller for the people.
Good morning to all. And the status of this matter?
We're ready.
Your Honor, the people are ready. However, we're asking to trail at least 2 days. I'm currently on call for OIS, and that is over as of Monday or Wednesday at 8 a.m. So I'd like to trail it at least until Wednesday.
Mr. Renge?
Your Honor, my understanding is that my client's timeout date is June 30th, not taking into consideration any of the orders by the California Supreme Court. We're ready to go. We have no objection if the court is inclined to release Mr. Lusk from custody. We have made a previous request, however, with COVID-19, I believe that's a changed circumstance, and I did file a motion with the court for my client's release.
Okay. Matter submitted?
Yes, Your Honor.
The request is to trail the matter 2 days. So the court will trail the matter at the people's request till June 17th. That'll be at 8:30 in this department for assignment out for trial. I note that the timeout date appears to be June 29th. And as Mr. Renge, you're saying that that does not take into consideration any of the Chief Justice's orders extending trials. If the 29th is the original timeout date under Penal Code Section 1382, the Chief Justice's orders would not have any impact on that date. So that would be the timeout date.
Okay.
Parties should be aware of that.
And that's my understanding as well, Your Honor.
So this matter is trailed until Wednesday for assignment out. Mr. Lusk, you are to be present at 8:30 on June 17th back in this department, Department 62. Anything further, counsel?
No, thank you.
Thank you. Calling matter People versus Corey Maddox.
Nicole Galston for the people.
Good morning, Your Honor. Alexandria de la Fuente, specially appearing on behalf of Roger Nuttall and 977 for Mr. Maddox.
Thank
Your Honor, this case is Dennis Versosa's case. He informed me that he and Mr. Nuttall had email communications with the clerk agreeing on dates. They were told that that would be sufficient for resetting dates. The dates are September 10th for trial confirmation, I believe in Department 30, with trial October 6th. And the understanding was that the general time waiver would remain.
Thank you. And Ms. De La Fuente, is that your understanding?
That is correct, Your Honor.
Right. And based upon counsel's agreement, the court will vacate today's trial date, set the matter for trial on was that October 6th?
Yes, Your Honor.
October 6th at 8:30 in Department 62. The settlement conference will be set for September 10th at 8:30 in Department 30. Each are to be present that date and time. And Mr. Maddox will remain on his bond status. The court will find good cause for his remaining on bond status under 1305 based upon the pandemic here today. Anything further?
No, Your Honor. Thank you.
Your Honor, just briefly,
Yes.
I've been asked to request that the court update the records to reflect that it is Roger Nuttall who is the attorney of record for Mr. Maddox and not Mr. Coleman.
Right. Thank you, Ms. De La Fuente. We'll see
Thank
to
you.
it that that takes place. Thank you.
Thank you.
Calling matter People versus Nathaniel Melendez. Any appearance on the matter of Nathaniel Melendez? According to the calendar, should be Eric Castellan for Mr. Melendez and Mr. Reynolds for the People.
Your Honor, I'll send Mr. Reynolds a message for you.
Thank you, Ms. Galson. We'll pass the matter for a moment. Calling matter People versus John Butrago.
Nicole Galson for the People.
I'm happy to be here.
And Mr. Meyer is appearing with Mr. Butrago. Good
Yes, sir.
morning.
Good morning.
And status?
Your Honor, the people are ready.
Mr. Avery?
Yeah, defense is ready. However, we have a 42-page plus transcript motion in support of our plea of once in jeopardy, and also an invitation for dismissal under 1385. I think that would need to be heard before the trial. We could be assigned out. I could be, I guess, eliminate, or if the court, I believe that people will probably want to respond to it. If the court will just set a time.
Just a moment. You were saying, Mr. Avery, that you have this document and then your speech was a bit muffled. So can you repeat that?
So I believe that people will probably like an opportunity to reply to it. But other than that, we're ready to go.
So has the motion or the pleading been served at this point?
No, I have it in my hand. I do have a copy for the people.
The people would like to, one, read the motion, and two, file a written response. The timeout under 1382 would be today. Given the court's emergency orders, the timeout for the trial would be September 14th, is my understanding.
Now, according to the court's records, there was a general time waiver still in this case. So is that inaccurate?
That's inaccurate, Your Honor. This is a case that we did a trial. It was a guilty on 2 counts, hung on other counts. That mistrial was declared April 15th, and it was set for trial again within a statutory time.
And Mr. All right. So given that there is a motion which has potential of being dispositive and has not been yet served on the people, what is your request?
Yeah, as far as the plea of once in jeopardy, that was entered previously. I have submitted documentation and motion in support of that plea, if I have the burden of proof on that. That's actually part of the trial, but there's also a portion of the motions dismissed pursuant to 1385, and that would be the part that people probably, you know this too.
I didn't understand the last part, Judge.
I'm sorry. This mask is not working for me. The people need the opportunity to do so. It's, I don't know if the court wants to hear the motion in this department or want to set in the law and motion calendar or set back with Judge Alvarez, who originally did the trial.
Well, Judge Alvarez does handle the law and motion calendar,
Yes.
but if this is a motion in limine or a pretrial motion, then that should probably be taken up in the trial department once the case is assigned out. It would probably be helpful to the judge to consider the motion if any written opposition by the people was also presented to the judge at the time the motion was presented.
Correct, John. So if the court wants to assign this to a department, I can file a motion in that department and continue it for time for people to reply.
Which would in effect tie up a trial department unnecessarily. So my suggestion would be that the document be served, the people be given an opportunity to respond, and once the parties have their pleadings prepared, it can then be sent to a trial department who can consider the motion and opposition as part of the pretrial motions and make a determination. How does the council wish to be heard?
I can serve that today. People will probably want at least a week or two to reply. Ms. Carlson?
That is correct.
And so it has to come back in 2 weeks from today.
Ms. Golson?
Your Honor, if we could come back June 29th or July 6th.
Have you a preference, Mr. Meyer?
No, yeah. June 29th, probably better.
Then the court will vacate today's trial date, set this matter for jury trial on June 29th at 8:30 in Department 62, noting that the timeout date is actually September 14th rather than a general time waiver in this particular case.
As far as that goes, I thought the court order would add additional 30 days and as opposed to another 90 days on top of the 60 that we already had in place.
When was the original timeout?
Today. So it falls under the court order because it expires today. But I thought it was just additional 30 days from the 60.
Well, I'd have to go back and read the Chief Justice's order and subsequent interpretations of that order, but the 15th is the cutoff. So if it were to time out today, I believe there'd still be 90 days available. If, again, today being the cutoff, if it's not an additional 90 days, then it would be, I believe, 60 days under the Chief Justice's original order. But again, either way, we would be well within that time if the parties proceed with their pleadings to get those properly before the court.
That's correct. Yeah. I think that even if it was 30 days, it still falls within that time and we can address that issue.
Understood. That we'll have that ironed out by the next hearing. Anything else?
Yeah, should I file this up on the felony court, or can I file it here directly in court?
You can file it with the clerk's office.
Thank you.
You're welcome. Thank you.
And Your Honor, on Mr. Reynolds' case, he informed me that he and defense counsel submitted an agreement to vacate the trial date today. I don't know if the court has that.
Going back to the Nathaniel Melendez case?
Yes.
All right. And what date had they requested?
Let me find out for you, Your Honor.
I'll let you know.
He's responding, Your Honor.
I'm sorry. Oh,
Your Honor, they agreed on June 26th for a settlement conference only.
and was it their understanding that the general time waiver would remain in effect?
Yes.
All right. And previously, Ms. Galston, you had said that you had spoken with Mr. Reynolds, and it was your understanding based on that conversation that he and Mr. Castellon had filed an agreement with the court to set this matter over. Is that accurate?
That is correct, Your Honor.
Okay. And this matter will be set over for a settlement conference until June 26th. That'd be at 8:30 in Department 11.
Thank you, Your Honor.
Thank you. Recalling the matter of People versus Nolan Travis. Excuse me, that's Travis Nolan. And Mr. Nolan is acting as his own attorney. Mr. Kim is appearing for the people. Has there been any further discussions as to any date for jury trial?
No. But I'd like to object to any motion for further continuance.
Okay.
Your Honor, if I may state on the record, last Monday, I believe it was June 8th, this court was, we had a jury trial set for the June 8th date. I was present, the court was present. We did call Mr. Nolan's case. The court issued a bench warrant, however, held the bench warrant until today's date. I had all my witnesses subbed on the 8th. They were released because there was a failure to appear on the 8th. So we don't have any witnesses subbed for today, Your Honor. Today was just to make certain that Mr. Nolan was going to show up for court or not. The court advised me to contact Mr. Nolan. I advised my investigator to contact Mr. Nolan and to advise him of today's date. And that's why he's here today. I don't believe we're set for a jury trial today, Your Honor, but just for whether the bench warrant was going to be issued or not today.
Okay.
Can I speak, Your Honor?
Just a moment, Mr. Nolan. Mr. Nolan, were you contacted by the DA's investigator to be here today?
Yes.
Okay. Yes, sir. You want to speak?
Yesterday, or last Monday, I was here at court. There was a number on the front door that I called, and they said that they were not admitting people into the building that day, and to come back or to call the next Friday and find out if he had been put on calendar.
Okay. Mr. Nolan, the court's not concerned about the bench warrant. The bottom line is the reason the court held any warrant because the court was concerned about whether you had received notice of the hearing date last Monday. So that's not an issue. What is an issue is that your case was actually scheduled to time out on April 13th. You've heard me speak, I'm sure, a number of times about the Chief Justice's order extending the timeout dates on cases. Your case would not time out for 90 days after April 13th. So I understand your objection, but I'm overruling your objection to any continuance requests made by the people at this point. That's why I had hoped that you and Mr. Kim would come to some agreement as to the date for any new trial. But you now have an opportunity to do that if you wish. But your case is not going forward to trial today, given the extension of time for timeouts and given the fact that the people had released their witnesses last week when you attempted to get into the court, but were not able to. So what date, gentlemen, would you like to have this matter continued for jury trial?
Your Honor, my understanding is that the time waiver was withdrawn by Mr. Nolan on February 17th, which would have made April 17th the initial timeout date. And then in addition to that, when we add 90 days, it would be July 16th would be the actual timeout date pursuant to the order by the California Supreme Court. The people's request today would be to continue the case out for a jury trial until July 13th. Then we will have another opportunity to sub all our witnesses and be ready for trial. I do also want to make a request with the court because I want to avoid any type of person-to-person conversation with Mr. Nolan. If he can be appointed a paralegal or investigator, so I can have any type of discussions with regarding whether it's discovery or any type of future hearings or what have you through the paralegal, if that's possible. If that's not, we'll continue forward as is, but people will be requesting July 13th for a jury trial date. And I don't believe Mr. Nolan needs to wait any additional time if people request that date.
Well, I would not be inclined to set this matter for July 13th if the timeout is the 17th, I believe you said, because the court's records indicate that the timeout would be set based upon a 4/13 timeout, not 4/17. But either way, counsel, if the issue is your ability to subpoena witnesses, that should take less than a month to do.
Your Honor, then people, I believe we can be ready by June 29th. It will give us 10 actual court days, Your Honor.
Mr. Nolan? Did you wish to be heard?
At this hearing, would I be able to introduce my Mill 100 veterans form?
At what hearing?
Here, would I be able to introduce?
I didn't understand that, Judge.
Nor did I. I'm sorry. So, Mr. Nolan, I'm sorry. Could you please repeat yourself?
There was a veterans form that was supposed to be filed originally and never was filed. That's why I had to fire my previous two attorneys, and I was wondering if I could introduce that as evidence today.
No, I'm not taking any evidence today.
A hard time, just so you know.
Okay. Mr. Nolan, please slow down and state again what you're trying to say.
Oh, well, you already answered the question. So.
Well, no, that's not quite clear, Mr. Nolan. The issue is all these proceedings are being transcribed. And so if the court reporter has difficulty hearing what is being said or understanding what is being said, that means we don't have a clear record of what took place. And it's usually in everyone's interest to be certain there's a clear record. So would you please repeat what you said about some form you wish to submit?
The submission of the form won't be taken in today, is what you said, correct?
What form are you talking about, sir?
A veterans form.
Okay. And what you specifically said, at least the way I understood it, is you wanted something to be taken into evidence today.
Yes,
is that what you said? Is that what you said?
I also have evidence to submit, but like you said, you're not taking.
Judge, I just want you to know that there's an audible difficulty. I just want to make my record on my end from some of these. I'm having a hard time understanding some of it's coming across muffled on my end. I don't know with you guys having a headset if it's different.
It is, I believe it is different. Mr. Nolan, what is it that you wish to submit to the court?
A Mill 100?
Your Honor, you're talking assist. I believe he is.
Mr. Kim, I don't need your assistance. I'd like to hear from Mr. Nolan. So what is the
100 form?
Mill 100?
Yes.
Okay. And you asking that the court receive that today?
Yes, sir.
And you asked that the court receive that into evidence?
Yes. And I also have other evidence that I would like to produce today.
Understanding, Mr. Nolan, that this is not the trial, it would not be heard before me, but rather it'd be assigned to another department. That's why I say the court would not take any evidence today, including the document that you may be referring to.
Well, the document that I'm referring to, the Mill 100, actually, I think is a jurisdictional document that has to do with veterans.
Okay. I would not be taking that today, sir.
Okay.
So, was there anything else from either of you?
No, Your Honor.
No, sir.
Then this matter will be continued for trial until June 29th at 8:30 in this department. Mr. Nolan and Mr. Kim, you are to be present that date and time. Mr. Nolan, the court will find good cause to excuse your alleged failure to appear last week. You remain on your current bond status. Thank you, gentlemen.
Thank you, sir.
All right, that leaves the matters of Jesus Ramos and the matter of Miss Henderson.
I don't know about it.
Could you do me a favor and tell Jeff?
Judge, do you have a Robert Mejia on calendar? This is Griffin Estes.
Yes, Mr. Estes.
Additionally, Your Honor, you also have a Louis Estrada on calendar for, just for a CPO issue. Probably an add-on.
All right. Then first, we'll pass the Mejia case for a moment, take up the matter of People versus Louis Ray Estrada.
And Your Honor, on behalf of Mr. Estrada, he is present here in court, also making management with the Office of FAC.
Keep them for the people.
And this matter had been set over for the issuance of a criminal protective order. Mr. Estrada was not present at the last hearing, but Mr. Nekomenis indicated he would contact Mr. Estrada and have him available today for purposes of service of a criminal protective order. Is that accurate?
Yes.
And Mr. Nekomenis, anything further on behalf of Mr. Estrada?
No.
Anything further from the people?
We just asked that the CPO be issued today, Your Honor. I served on Mr. Estrada today.
All right. Matter submitted?
Yes.
Mr. Estrada, you ordered not to have any personal, telephonic, written, or third-party contact with Manuel Medina Trujillo. You're not to come within 100 yards of this individual's residence. You are to surrender to local law enforcement or sell to a licensed gun dealer any firearm that you own or are subject to your immediate possession or control. You are not to attempt to or actually prevent or dissuade any victim or witness from attending a hearing or testifying or making a report to any law enforcement agency or person. This order will remain in effect for the entire pendency of this case, and you'll be served with a copy of the order by Deputy Garcia in one moment. Now, it's my understanding, counsel, what is the status of this case aside from the criminal protective order?
Your Honor, we have a trial date set.
Your Honor, we have a settlement conference set for August 13th. Correct. In the prelim court.
So just to be clear, the settlement conference is set for August 13th in the prelim department. Is that accurate?
Yes, Your Honor, with a general time frame.
Right. Then Mr. Estrada, you're already present on August 13th in Department 10. at 8:30, already present that date and time. Anything further in this matter?
No, Your Honor. No, Your Honor. Thank you.
All right, thank you.
Is on the Mejia matter, the court should probably know that Mr. Mejia is in line on the side.
And what is, this matter is allegedly on calendar for a 995 motion?
Yeah, Mr. Kim is the district attorney on this. He's in the courtroom. What happened right before the pandemic came down, I had filed a 995 motion, and then the court, Mr. Conklin and I, we met and we discussed Mr. Mejia's matter, and the court wasn't going to hear the 995 motion today, but the court had, I don't really know how to say it, indicated, I guess, a disposition.
Okay. And Mr. Kim, you were present for this?
Yes, Keith in for the people.
All right. So we'll counsel on Mr. Mejia's case and also counsel on Mr. Ramos. Please approach. We'll go off the record for a moment.
We go in the back.
In the hallway? He said yes.
Can you hear me, Judge?
I can.
Okay, back on.
We'll go back on the record and call the matter of People versus Jaquisha Henderson.
Good morning, Your Honor. Irene Luna, ADO on behalf. I'm sorry. Good morning, Irene Luna, ADO on behalf of Ms. Henderson. She's present in my office. We are appearing remotely by Zoom.
Justine Keel for the people.
Thank you all. The court has received a First Amendment information. Ms. Luna, do you wish to proceed to arraignment of Ms. Henderson?
Yes, Your Honor. I will acknowledge receipt of the first amended information, waive formal reading, further advisement of her constitutional and statutory rights. She will be entering a no contest plea to count 2, a violation of Penal Code Section 136.1 sub B2. The people have offered probation as well as to dismiss the remaining count. Judge Whitehead had previously indicated no additional custody time for this case. Ms. Henderson also has a probation case that will run concurrent.
Right, and is that the people's understanding of the agreement here?
Yes, Your Honor, and the people are okay with reinstatement on probation in that case as well.
Okay. So Ms. Henderson, I'm holding up this advisement of rights and change of plea form. Do you see this document?
Yes.
Can you speak up? Thank you.
Yes,
And did you read the document?
I did.
Did you sign and initial the document?
I did.
Have you any questions about the plea you are about to enter, the constitutional rights you're giving up by your plea, or the consequences of your plea?
No, sir.
Do you understand you're giving up certain constitutional rights, including your right to a speedy public jury or court trial, the right to be confronted by the witnesses against you, the right to not incriminate yourself, and the right to present evidence in your own defense?
Yes, sir.
You understand that if you are not a citizen of the United States, that this plea could result in your being deported, excluded from admissions, or denied naturalization?
Yes, sir.
Do you understand the maximum sentence you could face as a result of this plea would be 3 years in state prison? However, the plea agreement is you would be placed on felony probation. And the indicated from the settlement judge was you'd serve no additional time in custody. If after reviewing the probation report, this court concludes that you should serve additional time in custody or that you should go to state prison, do you understand that you would be allowed to withdraw your plea?
Yes, sir.
You understand that as a result of this plea, you can be ordered to pay a fine of up to $10,000 and be ordered to pay restitution up to that same amount.
Yes, sir.
And you understand that this plea would constitute a strike or a serious felony for any future felony convictions, meaning it can double the sentence you could receive for any future felony convictions.
Yes, sir.
And you also understand that as a result of this plea, you will be prohibited from possessing firearms and or ammunition.
Yes, sir.
And with all these consequences in mind, Ms. Henderson, do you still wish to go forward with your plea?
I do.
Counsel, to stipulate if the court will review the crime reports and or preliminary hearing transcript in this case, that the court would find a factual basis?
Yes, Your Honor, by the people, but with the addition of some jail calls that I provided to counsel.
We stipulate on that basis.
And were there transcripts prepared of the jail calls?
Yes.
And ma'am, are you Jaquisha Henderson?
Yes, I am.
Ms. Henderson, how do you plead to a felony violation of Penal Code Section 136.1 paren B paren 2, that is dissuading a witness from prosecuting a crime as alleged in count 2 of the first amended information? Guilty or no contest?
No contest.
Do you understand that a no contest plea is treated the same as a guilty plea for sentencing purposes?
I do.
The court finds the defendant has freely and voluntarily entered her plea. She understands the nature and consequences of the plea. The court finds that she has expressly, knowingly, intelligently, and understandingly waived her constitutional rights. The court finds there's a factual basis for the plea. Therefore, the court will accept the plea. Motion as remaining counts in this case ending in 530. As to Ms. Henderson.
Yes, move to dismiss count 1 as to her only in light of the plea.
Thank you. That motion will be granted. This matter will be referred to the probation department for preparation of a pre-sentencing report. The report and recommendation will be addressed on July 28, 2020 at 8:30 in this department, Department 62. Ms. Henderson, you already present that date and time. And apparently there is a pending probation case.
I have that case number, Your Honor.
Thank you.
F16905169.
All right, as to case ending in 169, based upon the plea in case ending in 530, the court will find you, Ms. Henderson, in violation of your probation in case ending in 169. That matter will be also set for sentencing on a violation of probation on July 28th, 2020 at 8:30 Department 62. You are ordered, Ms. Henderson, to report to the probation department to participate in an interview for the report of the probation officer. It's extremely important that you make the time appointed for your interview, because if you fail to do so, there will be no report which the court can use to go forward with your sentencing on July 28th. Do you understand that?
I understand.
And you understand that if you fail to abide by this order to appear at the probation department for the interview, that would be a real strong suggestion to this court that you cannot follow court orders. If you cannot follow court orders, then it's unlikely you can be placed on probation, because probation is, in essence, a series of orders that a person is expected to follow. Do you understand that?
I understand.
I also have this document, a prohibited persons relinquishment form. Do you see this document, Ms. Henderson?
Yes, I do.
And did you read this
Donna,
document?
can she keep her voice up, please?
Yes.
Yes,
And Ms. Henderson, did you read this document?
I did.
And did you also sign and initial the document?
Yes, sir.
Now there's a statement near what you say is your initial and signature, which reads as follows: I do not own, possess, or have under my custody or control any firearms, ammunition, or ammunition feeding devices, including but not limited to magazines. By signing and initialing near that statement, are you adopting that statement as your own?
Yes, sir.
Based upon the representation of Ms. Henderson, the court is directing the probation department to check the automated firearm system to verify the statement Ms. Henderson makes in this form. So Ms. Henderson, you ought to be present back in court on July 28th, 8:30, Department 62. You will remain on your current out of custody status at this point. The trial date as to Ms. Henderson is vacated. Anything further in this matter?
No, thank you.
Yeah. 1 second. Your Honor, actually, could we go out maybe 2 weeks for sentencing that coincides around her due date? And I just want to make sure we won't need to continue.
What date are you requesting?
I just say 2 weeks out past the 28th, if that, August 11th, if that's agreeable with the court and the people.
That's fine with me.
Now, Ms. Henderson, you have the right to be sentenced within 20 court days of your entering your plea. To give up that right so we can set your matter over until August 11th for sentencing? I'm sorry?
Yes, sir.
All right, with the time wait for sentencing, the hearing on the probation officer's report will take place August 11, 8:30 in Department 62. You already present that date and time. Anything further?
Your Honor, I do have the originals. What is the best way for me to get them to the court? I am planning to head over to the courthouse right now.
That would be great if you can deliver them to the clerk's office.
Okay.
The felony clerk's office.
Okay.
Anything further?
No, thank you.
All right. Thank you all.
Go ahead and do it. If you still want to take longer, I might run down Zoom or something.
Okay.
If not, I'm just gonna go this way.
Okay.
What did you say? You did.
I think Griffin still has to actually call his as well. They were talking about it back there. I don't know if this is. Robert Mejia? David Mejia? They got outside and talk. Oh, okay.
Hopefully soon. You're there for this corner? What's that? Is everybody out there for this corner? Okay. Yeah.
Like why important? No, you just want to make sure that it's way past. Well, it's in the definition of a sentence. It's all about the form of the court, and I finally found it. So.
What are they doing?
Are we still have.
This is the hallway. Oh, okay.
Yeah, I think we got some in here. I just came to tell him.
Wait, what do you mean? Wait. Not the block calendar, right? Are you talking about the bond calendar? Yeah. No, the bond calendar is here. The bond calendar is here. They told us that's
Mary for Jesus Rom.
Yeah.
What?
Do you want me to take some of that?
Oh, well, I'm not sure if you want to ask him first, but for Jesus Ramos, I have a misdemeanor change of plea form. He wasn't really clear earlier when we called it what the exact claim is, but that is a misdemeanor change.
The judge wasn't?
Yeah.
Okay, are these both of them?
Yeah, so that's a Prop 63.
Joe, do you want to mute that right now or no? No?
If you need me to, I can.
The mic.
Was that the bond calendar?
Yeah, I got it.
Okay, I'll give him this. So,
Yeah, I guess I first asked him if he wants them. I assume he will whenever we
Wants
do.
the what? I'm sorry.
Ask him if he wants those for Mr.
Okay.
Ramos' case.
Yeah, I think he does. Yeah.
Boy 68, boy 60. You have a number for 1021?
Madam Clerk, are you able to hear me? This is Martin Telesnik.
Question. Well, they're sending everybody to 61 when they should come to 62.
Martine, I can hear you. This is
Good morning, Mary.
Good morning.
I was wondering about bond arraignments and whether
Okay.
we want our clients to appear or if we can appear for them.
Okay, cool. Thanks. Okay.
Hold on, let me have Teresa. Are you getting that? Martine's talking to you on there, and he's asking if you can, and he wants to know about the bond arraignment. Just now. She's going to respond to you, Martine.
Thank you, Mary.
You're welcome.
No, it's sweet here. I'll just have you guys come in here. There's a blue piece of tape. I need everybody to sit at one of those pieces of tape. It's on top of the bench, okay? Social distancing, and you have to have a mask on. Okay, come on. Yeah, yeah, go ahead. You can sit out here also. So there's a piece of tape. Blue one. There you go. There's a blue one. And just so you know, there's audio in here. It's going to YouTube, so you don't talk right now, okay? And if you have your mask, you have to wear a mask, okay? Thank you. Yes, one person, I know for sure.
¿Alguien que requiera los servicios de un intérprete? ¿Su nombre? Roxana Martínez, ¿alguien más? ¿Cómo? Terzaret. Ríos, gracias. ¿Cómo? Gracias.
What?
Make sure your phones are off, please.
Returning to the master calendar and calling the matter People versus Jesus Ramos.
Jason Westerfeld, Public Defender's Office, on behalf of Mr. Ramos. He is present in Department 62 in custody, being assisted by the Spanish language interpreter. We are both present in 62, appearing virtually through Zoom.
Sandra Garcia for the people.
And again, I recited how we had discussed this, counsel and I, previously. And the legal issue came up concerning how this matter may be viewed by others, particularly in immigration court. It's my understanding that the people were going to reduce this charge to a misdemeanor in
Your Honor,
exchange for the plea.
Your Honor, that's actually incorrect. It was court indicated of a 17B.
Court indicated by another court?
Yes, Your Honor.
Okay.
By Alvarez, by Corona, and I'm sorry, who was the last one, Jason?
It was Alvarez, Corona, and then even Judge Capitan for a short time, but yes.
Mr. Westerfield, can you sit down so you're sitting in front of the microphone? Thank you.
Yes, of course.
All right. So the court will follow the recommendation of the prior judicial officers who have reviewed this case and have certainly have had more time discussing it with counsel than I have, because this matter just appeared on the master calendar, I believe, last week
Correct, Your Honor.
when we had our discussions. And if the record doesn't already reflect, the record should reflect that Mr. Ramos is being assisted by an interpreter in the Spanish language. And I believe the interpreter had previously given her name and credentials for the record in relation to another case. But Madam Interpreter, would you please state your name and credentials for the record concerning Mr. Ramos's case?
Yes, sir. The interpreter's name is Ana Garza Gonzalez. She is certified for Spanish by the state of California, 301629. Her badge and oath are on file.
Thank you, Madam Interpreter. So, Mr. Westerfield, is your client ready to proceed concerning the change of plea?
He is, Your Honor.
So, Mr. Ramos, I'm holding up this advisement of rights and change of plea form, sir. Do you see this document that I'm holding up to the camera?
Yes.
And also I have this second document, prohibited persons relinquishment form. Do you see this document that I'm holding up, sir?
Yes.
Did you read each of these documents with the assistance of the interpreter in the Spanish language?
Yes.
Have you any questions about the plea you're about to enter, the constitutional rights you're giving up by your plea, or the consequences of your plea?
No, everything is fine.
Do you understand that you are giving up certain constitutional rights, including your right to a speedy public jury or court trial, the right to be confronted by the witnesses against you, the right to not incriminate yourself, and the right to present evidence in your own defense?
Yes, yes, yes.
Do you understand that if you are not a citizen of the United States, that this plea could result in your being deported, excluded from admissions, or denied naturalization?
Yes.
Do you understand that deportation may be mandatory for this offense?
Okay.
Do you understand that, sir? Yes or no?
Yes.
Do you have you fully discussed this matter with your attorney and understand the serious immigration consequences of your plea?
Yes.
Do you understand the maximum sentence you could receive as a result of this plea would be 364 days in the custody of the Fresno County Sheriff?
See, yes.
You also understand that as a result of this plea, you can be placed on probation or to pay fees and fines or to pay restitution. You could be subject to search and seizure terms, and that you will be prohibited from possessing any firearms or ammunition.
Yes.
Are you entering this plea freely and voluntarily without any threat to you or anyone close to you?
Yes.
And with all these consequences in mind, sir, do you still wish to go forward with your plea?
Yes.
Your Honor, if I could just briefly interject, I think Mr. Ramos is also entering a plea with the understanding that the court would waive some or all of the time credits that Mr. Ramos has earned so far in this case.
Now, is it the court that'd be waiving those, or would it be Mr. Ramos waiving those?
It would be Mr. Ramos waiving those, but with the court's permission.
Anything further, Mr. Westerfeld?
No, Your Honor.
Right. So, Mr. Ramos, how do you plead to a misdemeanor violation of Penal Code Section 245(a)(1), that is assault by means likely to produce great bodily injury, again as a misdemeanor? Guilty or no contest?
No contest.
Do you understand that a no contest plea is treated the same as a guilty plea for sentencing purposes?
Okay, yeah.
Sir, is that a yes or a no?
Yes.
The court finds the defendant has freely and voluntarily entered his plea. He understands the nature and consequences of the plea. The court finds he has expressly, knowingly, intelligently, and understandingly waived his constitutional rights. The court finds there's a factual basis for the plea, therefore the court will accept the plea. Motion has any remaining counts?
Your Honor, there are no remaining counts.
Time waived for sentencing?
So waived.
Any legal cause?
No, Your Honor.
And how long has Mr. Ramos been in custody?
159 actual, 158 good time work time for a total of 317. And Mr. Ramos is wishing to waive all of those time credits, Your Honor.
That is correct, Your Honor.
All of the time credits?
Yes, Your Honor. And I've explained to Mr. Ramos the nature of that is where if there's any violation of probation, then he can be, he's waiving them for all purposes. So Mr. Ramos understands that.
Mr. Ramos, is that your understanding, sir, that you have currently been in custody for 158 days? As a result of that, you'd have 158 days of time credits added. So for a total, under the law, you would have served 317 days for this offense. It's my understanding that you wish to waive those time credits for all purposes, meaning that if you were placed on probation and it would violate your probation, you would be not entitled to receive any time credits for the time you've already served. You would begin any sentence on this case with 0 time credits. Do you understand that?
Yes.
And is that what you wish to do?
Yes.
And are you now waiving all 317 days of time credits for all purposes in this case?
Yes.
Anything further from either side concerning sentencing?
No, Your Honor.
And Your Honor, the people actually calculated 159 days if we were to count today, not 158, and would be requesting the stay away order from the location.
Stay away order from where?
The location of the Mosqueda Center, I have an address here. 4670 East Butler Avenue in Fresno, California.
All right, is the matter submitted?
I'm sorry, Your Honor, what was that?
Is the matter submitted?
Submitted.
By the people, Your Honor.
In this case, Mr. Ramos, the court will suspend imposition of judgment for a period of 2 years, place you on a grant of bench probation for that period of time under the following terms and conditions. At this point, the court is not going to order that you serve any time in custody on this case. You will be ordered to pay a fine in the sum of $500. That'd be payable at the rate of $35 per month, beginning on July 1st and on the first of each month thereafter until it's paid in full.
Your Honor, I apologize. Can I would ask for a waiver of the fine pursuant to Penal Code 2900.5 in light of the time credits that Mr. Ramos is waiving. I believe I would ask the court to consider waiving the fine in light of the time credits that Mr. Ramos waived.
And Mr. Ramos waived those time credits for a specific purpose, which is very advantageous to him.
That's correct,
So,
Your Honor.
was there anything else is there anything else?
I'll submit on my request.
Okay. To be clear, the court is mindful of the fact that Mr. Ramos is waiving 317 days of time credits. He's doing that because it's beneficial to him, my understanding, as was represented to me, for immigration purposes. So the court is taking that into consideration by not giving him any additional time in custody. The court does not intend to give him further consideration by waiving the fines which would ordinarily be imposed in this case. So the fine will remain at $500, payable at $35 per month, beginning on July 1st, then on the first of each month thereafter until it's paid in full. So you're ordered to obey all laws. You're not to possess or control any firearms or ammunition. You're also to pay any restitution that may be required, and the court will reserve jurisdiction or determine the amount of any restitution. You're not to have any association or contact with individuals at the Mosqueda Center, located at 4670 East Butler in Fresno. Do you understand where that location is, sir?
Yes.
And you understand that you are to stay away from there as a term and condition of your probation?
Yes, yes.
You're also to, well, were there any other terms, conditions recommended by the people?
Your Honor, I normally get the order of no dangerous or deadly weapons. You did the no firearms or ammunition.
And you're not to possess, control any dangerous, deadly weapons, including firearms and ammunition. Anything else requested, Ms. Garcia?
No, Your Honor, thank you.
Mr. Ramos, do you understand the terms and conditions of probation, sir?
Yes, yes.
Do you accept those terms and conditions?
Oh, Your Honor?
Yes.
I apologize. Did we do search and seizure terms? I did not write that down.
And what specifically about this particular case that would warrant those terms?
Your Honor, when the officers did a search of defendant, they found a hatchet on him.
Mr. Ramos, you are to submit your person, property, home, and vehicle to search and seizure at any time of day or night by a law enforcement officer, including a probation officer, with or without a search warrant or other process. Do you understand that, sir?
Yes.
So that'll be an additional term of the probation here. Sir, you understand the terms, condition of probation?
Yes,
Do you accept those terms and conditions?
yes.
Then that'll be the court's order. I asked you previously about this prohibited persons relinquishment form. You said you had read this with the assistance of the interpreter in the Spanish language. Did you also sign and initial the form?
Yes,
By signing and initialing this form, did you adopt this statement as your own? Quote, I do not own, possess, or have under my custody or control any firearms, ammunition, or ammunition feeding devices, including but not limited to magazines, unquote. Are you adopting that statement as your own, sir?
yes,
Then the court's directing probation to confirm Mr. Ramos's statement concerning the lack of possession or control of firearms. Anything further?
No, Your Honor, thank you.
The trial date is vacated. Good luck to you.
Thank you, Your
Your
Honor.
Honor.
I believe that concludes the,
Judge, what about Mejia?
we do have one other matter. People versus Robert Mejia.
Griffin Estes on his behalf. He's present in the courtroom. Do you approach counsel's table?
Keep him for people.
And the court and council did have some discussions about Mr. Mejia's case a moment ago. Apparently, that at a time when I was covering the law and motion calendar, we had some discussions prior to any motion being heard. And the court had indicated. How do you wish to proceed today?
I've submitted a change of plea form with the court. We'd like to move forward. The court's indicated.
Mr. Kim, do you wish to be heard?
Your Honor, it will be basically a straight up plea, and then we'll submit on that.
I'm sorry. Mr. Kim, why don't you sit at the microphone and speak? Sorry.
Sorry, it will be a straight up plea, Your Honor.
All right, Mr. Mejia, I have this felony advisement of rights and change of plea form that I'm holding up, sir. Do you see this document?
Yes. Yes.
And did you read this document?
Yes.
Did you sign and initial the document?
Yes.
Have you any question about the plea you are about to enter, the constitutional rights you're giving up by your plea, or the consequences of your plea?
No, sir.
Do you understand you're giving up certain constitutional rights, including your right to a speedy public jury or court trial, the right to be confronted by the witnesses against you, the right to not incriminate yourself, and the right to present evidence in your own defense?
Yes, sir.
Do you understand that if you are not a citizen of the United States, that this plea could result in your being deported, excluded from admissions, or denied naturalization?
Yes, sir.
You understand the maximum sentence you could receive as a result of this plea would be 3 years in state prison. However, the plea agreement is, or the discussion is, that, and let me be clear, it is this court's indicated that this is not a prison case, notwithstanding your criminal history. If after reviewing the probation report, the court concludes that this is a prison case and that you should be sent to state prison, do you understand that you would be allowed to withdraw your plea?
Yes, sir.
You understand that as a result of this plea, you could be fined up to $1,000 and, $10,000, and also be ordered to pay restitution fine up to that same amount.
Yes, sir.
Do you also understand that as a result of this plea, you can be prohibited from possessing a firearm or ammunition?
Yes, sir.
And with all these consequences in mind, sir, do you still wish to go forward with your plea?
Yes, sir.
Counsel, to stipulate if the court review the crime reports in this case, the court would find a factual basis?
By the defense, there's also a preliminary hearing transcript we can stipulate too.
By the people.
Thank you. And just one moment, counsel. And Mr. Mejia, how do you plead to a felony violation of Penal Code Section 594 paren B paren 1, that is vandalism with damage over the amount of $400? Guilty or no contest?
No contest.
Do you understand that a no contest plea is treated the same as a guilty plea for sentencing purposes?
Yes, sir.
Now, it's further alleged in the information, sir, that you suffered a prior serious or violent felony within the meaning of Penal Code Section 667B through I and 1170.12 A through D, or the strike law. These felony convictions could have the impact of doubling, and in certain instances, tripling, or making you subject to a 25 to life sentence as a result of any plea in this case. Do you understand that?
Yes, sir.
The first allegation is that you suffered a conviction for violation of Penal Code Section 245 paren A paren 1. That would be a strike. It's alleged that took place on or about November 10, 2014, in case VA 134-87101 in the Los Angeles Superior Court. Do you admit or deny having suffered that prior conviction?
Yes, sir.
Admit or deny?
Admit.
It's secondly alleged, based on the same case from Los Angeles County, that you suffered a second violation of Penal Code Section 245 paren A paren 1, in that case ending in 401 on or about November 10, 2014. Do you admit or deny that allegation?
Admit, sir.
Your Honor, I'm sorry, just for the record, I believe it's a different case. The first case ends in 101. The second case ends in 401.
Thank you, Mr. Kim. I stand corrected. The second offense, Mr. Mejia, allegedly took place in case VA 134-96401 on that same date, November 10, 2014, in the Los Angeles Superior Court. Do you admit or deny having suffered that second serious or violent felony on that same date, November 10, 2014?
Admit, sir.
And Mr. Kim, is there a reason for an admission to the other felonies within the meaning of 1203 paren E paren 4?
Well, Your Honor, if the court finds unusual circumstances, I don't believe those admissions are necessary at this time.
And the court finds the defendant has freely and voluntarily entered his plea, understands the nature and consequences of the plea. The court finds he has expressly, knowingly, intelligently, and understandingly waived his constitutional rights. The court finds there is a factual basis for the plea, therefore the court will accept the plea. And basically the defendant admitted everything in the information except for the prior convictions, two of which he already admitted, as those amounted to strikes. And the third one was for an alleged 496 from 1994. Each of these three allegations were made under Penal Code Section 1203 paren E paren 4, which I tend to concur with Mr. Kim would not have any bearing here. This matter will be referred to the Probation Department for preparation of a pre-sentencing report. The report and recommendation council we would set in this department. Did you want to set within statutory time?
Mr. Mejia would be willing to waive time to a date that's convenient to the court.
What date would you request?
Is a Friday or Thursday better for the court? Could we do Thursday, July 23rd?
Mr. Kim?
Submitted, Your Honor.
Then Mr. Mejia, you have the right to have your sentencing take place within 20 court days of your entering your plea. To get up that right so we can set your matter for sentencing on July 23rd at 8:30 in Department 62.
Yes, sir.
or the time waived for sentencing. So you're ordered to appear on July 23rd at 8:30 in this department, Department 62, for sentencing in this matter. You're remanded with no bail in this case pending sentencing. We'll see you back here on July 3rd at 8:30. Anything further in this matter?
Your Honor, may I request that he
July
remain
3rd,
out
there.
on his own recognizance or on the Rule 4?
I'm sorry, say that again.
Did the court remand Mr. Mejia?
Oh, forgive me. I'm sorry. I had forgotten, frankly, that Mr. Mejia is out of custody. No, he is not remanded. He remains on his current bond status, and he is directed to report to probation for preparation of the pre-sentencing report.
And Judge, you said July 3rd on the last one instead of 23rd.
Thank you. To be clear, the sentencing is set for July 23rd at 8:30 in this department, and Mr. Mejia, you already present that date and time. Anything further?
No, Your Honor, thank you.
All right, thank you. The trial date is vacated.
Thank you.
Know to come here though to the courthouse, get a letter or something. Oh, yeah. Yes, I was just curious how they're doing.
I believe that concludes the master calendar. Court will take a brief recess before beginning the bond calendar. It'll be just a few moments, about 2 minutes, frankly. right, turning to the surety bond calendar. Please stand when your name is called. LMA Thomas Carter.
Your Honor, Martin Telesnik appearing for Ms. Carter.
Thank you. The court has received a memorandum from the district attorney's office indicating that no charges will be filed. So the bond in this case would be exonerated.
Thank you very much, Your Honor.
You're welcome. Christina G. Jimenez. Good morning. Randy William Kestner.
Stay standing, please.
Randy William Kestner. Roxana Castro Martinez. Thank you. All right, Ms. Jimenez and Ms. Martinez, the court has received a memorandum from the district attorney's office stating that they do not intend to file charges in your cases. So the bond in your cases will be exonerated. You are free to leave. Thank you all both. The court also had received a memorandum concerning Randy Kestner. The bond in that case will be exonerated as well. Please stand when you hear your name called and remain standing. Devonay Brazil.
Yes, sir.
Thank you. Allison Fujishwa. Thank you. Elizabeth Rubinos Moreno. Is being assisted by an interpreter in the Spanish language. And Madam Interpreter, would you state your name and credentials for the record?
Yes, sir. The interpreter's name is Ana Garza Gonzalez. She is certified for Spanish by the state of California, 301629. Her badge and those are on file.
Thank you. And Jose Ventura. Jose Ventura. Each of you who are standing are making your first appearance on the bond calendar. Up to this point, there's been no complaint filed in your respective cases. The court finds good cause to continue your cases pursuant to Penal Code Section 1305. The court continues the matter for arraignment 16 days until Wednesday, July 1st, 2020 at 8 a.m. in room 401 on the 4th floor. You're each ordered to be present and report that date and time. You should get a calendaring memo from Deputy Garcia. Thank you very much for your time.
Push it, push.
And please stand when you hear your name called. Siobhan DeAndre Brown. Thank you. Jack Fenton. Jack Wade Fenton. James Hanna. Jatarius Johnson. Thank you. Anthony Rivera. Thank you. Paloma Sanchez. Thank you. Each of you are making your second appearance on the bond calendar. So you have the option of either having your bond continue in effect in the event, so that if the district attorney decides to file charges, you don't need to post another bond, or you can have your bond exonerated or canceled at this point, in which case, if the district attorney's office does file charges, it may be necessary for you to post a new bond. It's entirely up to you whether you wish to have your bond remain in effect or not. If you have your bond remain in effect, then I will set your case over until August 28th, 2020 at 8 a.m. in room 401 for your appearance. So first, Mr. Brown, do you wish to have your bond remain in effect or have it canceled at this point? I'm sorry, Mr. Brown, can you step closer to the front of the courtroom?
Just kind of speak loud. You said if I keep my bond posted, what was options?
I'm sorry, Your Honor. I cannot hear him.
Understood. Mr. Brown, you had a question, sir?
Yes. If my bond stayed posted, what were the options again? I couldn't hear back there.
If your bond remains in effect, then you would be asked to return on August 28th. And if charges aren't filed by then the court would exonerate your bond or cancel your bond at that point.
Okay, and then my bond gets canceled, what happens? If my bond gets canceled, what happens?
If your bond gets canceled now, then you're free to go. But if charges are filed later, you may be required to file a new bond.
Okay, the second one.
So
I'm
you
sorry,
wish,
Your Honor. I
you wish to
cannot
have,
hear him.
are you asking that the bond be extended? That you come back on, be asked to come back on the 28th of August?
Yes. No.
All right. Then you are to be present August 28th at 8 a.m., room 401 on the 4th floor. Thank you, Mr. Brown.
You're welcome.
And James Hanna, could you step up to the microphone?
Yeah, step up here, please. Speak loudly, okay?
And Mr. Hanna, would you like to have your bond remain in effect or would you like to have your bond canceled at this point?
Remain in effect.
All right, sir, then you're ordered to return on August 28th at 8 a.m., room 401 on the 4th floor. Thank you, sir. Mr. Johnson?
Yes, sir.
Mr. Johnson, would you like to have your bond remain in effect or have it canceled today?
Remain.
Then, sir, you are to appear on August 28th at 8 a.m., room 401. Thank you, sir. Anthony Rivera,
Remain.
you wish to have your bond remain, sir?
Yes.
Then you are to be present on August 28th at 8 o'clock, room 401, sir. Thank you.
Hey.
Paloma Sanchez.
Yes, Your Honor.
And Ms. Sanchez, do you wish to have your bond remain in effect or cancel at this point?
It remain in effect.
Then you're ordered to appear on August 28th at 8 a.m., room 401. Thank you. Please stand when your name is called and remain standing. Jordan Oliver.
Morning.
Good morning. And Mary Torres.
Good morning, Your Honor. Robert Troncoso appearing 977 on behalf of Ms. Torres.
Thank you. In each of these cases, the case of Ms. Oliver and Ms. Torres, there have been no charges filed up to this point. They're each would be making their third appearance on the bond calendar, and no complaint has been filed. The court orders that the bonds in each of these cases be exonerated or canceled.
Thank you.
Anything?
And I'm sorry, Your Honor, I did not get counsel's appearance.
Counsel, can you state your name once again?
Yes, it's Robert, and the last name is Troncoso. It's Troncoso.
Thank you, Mr. Troncoso. And thank you, Ms. Oliver. Your bond's being exonerated.
Thank you. You have a good day.
You too.
Thank you, Judge.
Thank you, sir. And we have one person remaining. Your name?
Michael Poblano. They said they gave you a piece of paper. They said,
And sir, your last name once again? I got the Michael. What's your last name?
Poblano, Poblano. What was the last one? I've been in court a long time ago.
And Mr. Poblano, I'm not seeing your name on our list for the bonds.
Judge, he was actually jail released. He just needs to go back down to B1 so that they
Oh.
can mark that he was present. They have it
Thank you.
confused.
Okay, sir, so you need to go back. Did you hear what my judicial assistant said?
Kind of B1.
B1, that's where they're having on the B1 level. Once you get off the elevators, turn to your right towards walking towards the glass windows, and then turn towards the right again. Someone there will be able to direct you when it is you need to return, sir.
Oh, okay. So, where you get that paper from? Oh, downstairs. Over downstairs. Yes. Okay, so I have to record again then.
They'll tell you when.
Okay. All right.
All right, sir. Have a good day.
Whatever it is. Okay. Thank God bless you.
Thank you.
So you were just supposed to come and check in.
Oh, okay.
Also on calendar was a Shelby Harris, Shelby Michael, M-Y-K-E-L Harris. There's been no appearance by this individual, and it's unclear which. Well, we'll go off the record for a moment.
Which were after, yeah.
They're just supposed to just make sure you check in. That's all they're supposed to do. That's send you up here.
And then, but then, are you are going to say this can
Okay.
I don't know if you need to.
All right, returning to the bond calendar. On calendar today was Shelby Michael, M-Y-K-E-L Harris. He was on the bond calendar, but apparently a case has been filed against Mr. Harris, or this individual, last name Harris, case M209-14396. So this matter will be taken off the bond calendar given that a case has been filed. Also, Randy Kestner had failed to appear, but there had been a memorandum showing that the people were not filing any charges against Mr. Kestner. Also, there was a failure to appear by Jose Ventura. Mr. Ventura would have been making his first appearance on the bond calendar. If he appears at the clerk's office before 1:30, then unless he appears at the clerk's office before 1:30, then the bond would be exonerated. If he appears before 1:30, then if he wishes, the bond will remain in effect. He'll be given a new date to appear. Also, there is no appearance by Jack Fenton. Mr. Fenton would have been making his second appearance before the court on a not yet filed surety bond. If he appears before 1:30, he can make the election as to whether his bond will remain in effect or be exonerated. If he does not appear by 1:30, the bond would be exonerated. I believe that covers the bond calendar. We're in recess.